Greetings. This is attorney Della Welch doing the third recording on what to do on the death of a loved one. In listening to the first recording, I discovered I made an inadvertent error. I said that my father had been buried in a museum, and I meant to say mausoleum. So I wanted you to correct that. My father was a custodian that swept the floors of a college for 34 years, and he was lucky enough that his daughter went on to become an attorney and a professor. So at the time he bought the mausoleum, it was very inexpensive, but at the time he died at 87, it was very expensive. So nowadays many people are being cremated because the casket funeral is very expensive, and of course the mausoleum funerals even more expensive. I also wanted to say a little more about the community property with right of survivorship. We talked about couples who have property in joint tenants. However, for tax advantages, often the preferable way of holding it is to hold it as community property with right of survivorship. On death of one of the parties, the law permits the other party to have a stepped-up basis, so the property steps up to its fair market value, so there is no capital gain, and this also avoids probate. You can refer to the tax code of the United States, section 1014A, for a description of this rule, and you may want to discuss this with your tax accountant, or you may want to discuss it with an attorney. Then when the surviving spouse dies, the asset steps up again. So this is a very important thing to understand, the difference between joint tenancy with the right of survivorship and community property with the right of survivorship. Other assets don't get that stepped up basis, such as 401k and other type of benefits. So make sure that you review that carefully. And we need to give a definition of what probate means. A probate court is a court that deals with deciding if a will exists and whether or not it is valid, and who are the descendant, heirs, and beneficiary. The court figures out how much the property is worth and the financial obligation. They say there's two ways to die, with a will or without a will. So it's important to understand about the probate court. We mentioned one disadvantage is if you probate an estate, it's public and not private. So many people don't like their affairs disclosed to others. There are certain fees, so costs are an important factor. In California probate code, the California probate code states that the fee is 4% of the first 100,000, 3% of the next 100,000, and 2% of the next 800,000. So you can check the probate code for amounts of an estate higher than that. Plus there are additional other costs. There's court costs of filing, there's fees for personal representative, there's also attorney fees that are required. So if you can avoid probate, it's often a good idea. You need to discuss this with your attorney and your tax lawyer. There's also power of attorney. There's special power of attorney. Suppose if I were going to buy a home and I couldn't fly to the state of Mississippi to purchase it, I could have a special agent given the power just to do that. There's also durable power of attorney. And the one very good thing about that is if you, as the grantor, are the one making the power of attorney, if you lose capacity, the person handling your affairs will be able to handle things after that time. So that's an advantage of that. I have found that some banks and other companies do not accept a durable power of attorney. But the special power of attorney forms and the durable power of attorney forms are on the Google, and you can Google those and know which has to be notarized and what the procedures are. Also in California, there's a California living will, and this is a legal document that allows you to give specific instructions on how you want your medical affairs handled and who you wanted to be the one to make those decisions in case you lose capacity. In California, this is often known as an advance directive. And they have to be a resident of California, at least 18 years of age, and mentally competent. Also, there's an advanced health directive, and that's a form you can find on the web as you can find a living will form. And this allows someone else to handle your affairs if you become incompetent. You need to have 2 or more adult witnesses who can testify that you have the mental competence to sign this document or have it notarized, and you have to do it of your own volition. No attorney fees are required, and you can find an advanced health directive online. I find when I go in the hospital, they always ask me, do you have an advanced health directive? And if not, the hospital sometime has the forms that you need. California has a do not resuscitate form, which is called DNR. This is a document signed by the patient and their physician, and that will prevent paramedics and emergency personnel such as EMT from performing any medical procedure on an individual whose heart has stopped beating or who has stopped breathing. So it's important to get your documents in order to make sure that the appropriate person has those documents. And we're not discussing here today whether Medi-Cal can have a lien on your estate if you have to go to a rest home, or any lien of Medicaid. That is something that is beyond the scope, and you'd have to research. So we hope that this has provided you several ideas of what to do to get your estate in order and to make sure the death of your loved one is in order. And this is not meant to be any legal guide, but to provide tips of basic information that you can study in more depth. There's also a book by Bernard Witkin, W-I-T-K-I-N, that's an encyclopedia of California law. It's said you can find the answer to any question in 5 minutes, so you may want to go to a law library and research some of these terms in the Bernard Witkin book. This will be the end of the presentation.